A federal judge is prepared to jail the director of the FBI, not after a trial, not after appeals, but within days. Pause and let that sink in. This is not a scandal. This is not political drama. This is the American constitutional system reaching a breaking point and testing whether it still functions when power refuses to obey law. In a federal courtroom, a judge issued a warning so blunt it shook the room. Comply with the court's orders or be arrested and detained until you do. No negotiations, no extensions. No privilege left to hide behind. This moment is not about one man. It is about whether judicial authority still means anything when it confronts the highest levels of the executive branch. When court orders are ignored, democracy doesn't collapse loudly. It erodes quietly until suddenly it doesn't work at all. If you believe the rule of law should apply to everyone, including those at the top, you need to understand how we arrived at this moment. Because this crisis didn't begin in that courtroom, it began long before the threat of arrest was ever spoken. To understand why a federal judge reached for the most extreme weapon the judiciary possesses, we have to strip this story down to its core. This is not about decorum. It is not about process errors. It is about a direct collision between two constitutional powers, one that gives orders and one that decided not to follow them. For months, the court issued clear, lawful directives, released specific documents tied to the Jeffrey Epstein investigation. Documents already reviewed, documents already ruled non-classified, documents already declared outside any legitimate claim of privilege, not once, not twice, but repeatedly. And each time, the response was the same: delay, obstruction, a new excuse layered on top of an old one, executive privilege, attorney-client privilege, ongoing investigations, national security, every justification recycled even after multiple courts rejected them outright. Here is the critical point. Courts can tolerate disagreement. They cannot tolerate defiance. When an executive official decides that court orders are optional, the system enters dangerous territory. Because at that moment, the question is no longer what the law says, but who has the authority to enforce it. And that is the question now hanging over this entire crisis. To answer it, we need to look backward into the history, the patterns, and the machinery that produced this confrontation in the first place. This confrontation did not begin with a threat of arrest. It began with a habit, one that has quietly reshaped how power operates in modern America. Over time, executive agencies learned something dangerous. Delay works. If you stall long enough, if you bury requests under procedure, if you flood courts with privilege claims, consequences often fade. Political cycles move on. Public attention shifts. Accountability dissolves. That strategy works until it doesn't. In this case, the judiciary followed a familiar path at first. It granted time, it allowed extensions, it reviewed claims carefully, methodically, patiently. The system behaved exactly as it was designed to behave: cautious, restrained, respectful of separation of powers. But patience has a limit. Each rejected privilege claim narrowed the legal space for defiance. Each missed deadline transformed bureaucratic delay into willful resistance. What began as a legal dispute slowly hardened into something else, a test of whether court orders were still binding or merely advisory. History matters here. Democracies don't usually collapse through sudden coups. They erode when institutions stop enforcing boundaries, and powerful actors learn that nothing happens when they say no. By the time this case reached the courtroom in December, the judge wasn't reacting to a single act of noncompliance. He was responding to a pattern months-long, systematic, and deliberate. And once a judge recognizes a pattern of defiance, the law demands escalation. That is how a routine document dispute turns into a constitutional crisis. And in the next moment of this story, escalation becomes unavoidable. The crisis detonated the moment the courtroom realized patience was no longer working. December 17th was not scheduled to be historic. It was supposed to be procedural, another compliance hearing, another exchange of arguments, another request for more time. That expectation lasted less than 2 minutes. The judge didn't open with legal theory. He opened with a question so simple it eliminated every escape route. Will you comply with this court's order, yes or no? There was no room left for interpretation. No ambiguity. Months of rulings had already stripped away every claim of privilege. Every delay tactic had been examined, rejected, and documented. The law had spoken clearly, and still the answer did not come. What followed was not defiance by accident. It was defiance by choice. A refusal framed as concern, as review, as responsibility. But in a courtroom, words matter less than actions. And the action was clear. The order would not be obeyed. That was the moment the tone shifted. You could feel it. The judge was no longer managing a dispute. He was confronting obstruction. In law, there is a line you can approach, argue about, and circle for months. But once you step across it, the system is forced to respond. That line was crossed in that courtroom, and once crossed, only one tool remained. What most people miss in moments like this is the mechanism underneath the drama, the part that makes this confrontation unavoidable once it begins. Courts do not have armies. They do not control budgets. Their authority exists only if their orders are obeyed. And when they are not, the judiciary has exactly one enforcement tool left: contempt. Contempt of court is not symbolic. It is not rhetorical. It is the legal system's emergency brake. When pulled, it bypasses politics, bypasses negotiations, bypasses public relations. It goes straight to physical enforcement. That is why this moment matters so deeply. Once a judge determines that defiance is willful, not confused, not accidental, not temporary, the law stops asking politely. Criminal contempt allows immediate detention, not as punishment, but as coercion. You are held until you comply. No hearing required. No further debate. This is not about vengeance. It is about preserving the structure itself. If a court backs down after issuing lawful orders, it teaches every powerful official the same lesson. Ignore us long enough and nothing happens. That lesson is fatal to constitutional government. So when the judge leaned forward and made the stakes explicit, he wasn't escalating emotionally. He was following the logic of the system to its final step. At that point, the question was no longer legal. It was existential. And in the next phase of this story, that existential pressure becomes impossible to ignore. The second crisis emerged the instant the deadline was spoken out loud. December 20th, 5 o'clock, not as a suggestion, but as a point of no return. Deadlines change psychology. Until that moment, everything could still be framed as negotiation, as process, as delay, but a fixed hour transforms defiance into a countdown. Every minute after that becomes a choice, and every choice carries consequences. Inside the courtroom, the balance of power shifted visibly. The confident bureaucratic posture collapsed under something far heavier than politics: inevitability. There would be no more extensions, no quiet settlements, no procedural exits. The judge made something else unmistakably clear. This would not be a symbolic standoff. Federal marshals were prepared. The mechanism was already in motion. If compliance failed, enforcement would follow automatically, impersonally, without spectacle. That is what made this moment so destabilizing. For the first time, an executive official at the very top of the federal law enforcement hierarchy was facing the same reality as any ordinary citizen who defies a court order. No special rules, no institutional immunity, just law applied mechanically. And when power realizes that it may actually be treated as equal before the law, panic sets in. Because from that moment forward, every option leads to damage. Comply and expose what has been hidden, refuse, and trigger an institutional shock unlike anything seen before. By the end of that hearing, the crisis had moved beyond law. It had become human. And that is where the consequences begin to ripple outward toward people who never set foot in that courtroom. Now, let me bring this down to where it actually lands on you. Because constitutional crises don't stay inside courtrooms. They move outward quietly into everyday life, into what you trust, into what you assume still works without your attention. When the head of the nation's top law enforcement agency defies a court order, the message doesn't stop at Washington. It reaches every police officer, every prosecutor, every citizen who is told that the law is neutral and binding. It forces a brutal question. If rules don't apply at the top, why should anyone believe in them below? This is how public faith erodes, not through ideology, but through inconsistency. One set of rules for power, another for everyone else. And if you're thinking this has nothing to do with your daily life, that's exactly the danger. Systems don't fail when people are angry. They fail when people disengage, when they stop believing accountability is real. If you care about living in a society where law still protects rather than performs, this moment matters to you. Not because of the names involved, but because of the precedent being written in real time. Pay attention, talk about it, share it. Not to inflame, but to insist that law still means something. Because once citizens stop demanding accountability, institutions stop offering it. And what happens next will decide whether this crisis ends here or spreads far beyond one courtroom. Once a constitutional crisis crosses national attention, it never stays domestic for long. Around the world, governments watch moments like this closely, not because they care about American court procedure, but because the United States has long claimed something larger, that its institutions are stronger than its politics, that laws bind leaders, not just citizens. When that claim is tested, the signal travels fast. Allies measure reliability through institutional stability. If executive power can defy judicial authority without consequence, trust weakens not only in leadership, but in agreements, enforcement, and long-term commitments. Lawlessness at the top creates uncertainty everywhere else. Adversaries, meanwhile, draw a different lesson. They point to moments like this and say, look, even their system bends when power is threatened. The credibility gap widens. Moral authority shrinks. There is also a quieter ripple effect. Global investors, legal systems, and international courts rely on the assumption that American rule of law is predictable. When predictability fractures, risk rises, and risk always has economic consequences. This is why the outcome of one courtroom confrontation matters far beyond Washington. It becomes a data point in how the world recalibrates its expectations. Not based on speeches, not based on ideals, but based on enforcement. And that brings us to the most difficult question of all. What happens next? Because from here, the future does not move in one direction. It splits. From this point forward, there are only three possible futures, and none of them are abstract. The first is compliance. The documents are released, fully and unredacted. The immediate crisis ends, but something else begins. Trust is shaken. Political consequences cascade. Institutions survive, but scars remain. The system holds barely by proving that defiance has limits. The second future is partial obedience, selective release, redactions disguised as caution, an attempt to satisfy the letter while evading the spirit of the order. This path is the most dangerous because it invites escalation. Courts respond, contempt deepens. The conflict stretches longer, louder, more destabilizing than before. The third future is outright refusal. The deadline passes. The warrant is signed. Federal marshals act. An FBI director is detained for contempt of court. This would not just be historic, it would be seismic. It would force an institutional reckoning no administration could control. Each scenario carries a cost: legal, political, psychological. What matters is not which outcome feels preferable, but what each one teaches the system. Democracies are shaped less by their ideals than by their enforcement mechanisms. What is tolerated becomes precedent. What is enforced becomes structure. This is why moments like this are rare and decisive. They compress years of institutional drift into days. They reveal whether law is still a governing force or merely a suggestion backed by tradition. The future will be decided not by rhetoric, but by action taken or avoided when the clock reaches zero. And when it does, there will be no ambiguity about what the system truly is. Only clarity. This is how constitutional moments end, not with speeches, but with enforcement. When the clock runs out, there will be no room for interpretation. Either the law is applied evenly, or power proves it can outweigh accountability. There is no middle outcome that preserves trust. There is no quiet resolution that avoids consequence. What makes this moment so revealing is its simplicity. A court issued lawful orders. An official refused to comply. Everything that follows flows from that single decision. Strip away the politics, the names, the narratives, and the system becomes visible. If compliance happens, it will reaffirm a principle older than any administration. No one decides which laws apply to them. If arrest happens, it will send a shock through every institution, but it will also confirm that enforcement still exists when it matters most. And if nothing happens, if deadlines pass without consequence, then something far more dangerous will have been established. Not corruption, not scandal, but permission. This is why you should not look away. Not because this story is sensational, but because it is structural. It answers a question every society eventually faces. When power refuses limits, does the system respond or retreat? What comes next will shape far more than one career or one investigation. It will define whether rule of law remains a reality or becomes a memory. If you want to understand how the next phase unfolds and what it means for everything that follows, stay with me. This story isn't ending here.